Good morning. My name is Jean Fisher, and I am here as the State Director for Right on Crime. Right on Crime recognizes the impact of fentanyl in our communities and the devastating effects that it is having on our loved ones and our families. I'm not here to concentrate on the fentanyl issue. I'm here to concentrate on the drug-induced homicide issue today. I'd like to address both the efficacy of the drug-induced homicide portion of House Bill 406, as well as some of the unintended consequences. I come to you as a retired Ada County prosecutor. I've served 33 years in that position and have prosecuted some of our worst cases involving child sexual abuse, serious crimes, as well as my fair share of murders. In Idaho, we essentially have 4 murder categories. We have first-degree murder, which is premeditated, malice aforethought, excluding capital crimes, and that carries life with 10 years. We have second-degree murder, which is the reckless disregard for life without premeditation. It carries 10 years and up to life. We have voluntary murder, which is in the heat of passion, rage. It carries up to 15 years. Involuntary murder is a criminal act without the intent to kill, and it carries up to 10 years. No mandatory minimums on either voluntary or involuntary murder. Now we have this drug-induced homicide, and I'd like to ask, how does it compare to what we already have in existing law? It does not require, it does require a criminal act, that is the turning over of drugs, but it does not require any intent to kill. It sounds very much like involuntary manslaughter, and quite frankly, it's much easier to prove. Causation issues in the drug-induced homicide is very difficult. How do you prove that the last person who gave something to someone caused their death? It is a problem. Most people involved in this are polysubstance abusers, and they're going to get ensnared by it. I'm also very concerned about the juvenile aspects of this because they will fall under the mandatory auto waiver for juveniles, which is a huge issue that you should be concerned about.
Okay. Any questions, Ms. Fisher? Representative Young.
Thank you, Mr. Chairman and Ms. Fisher. Could you speak just a little more to the last part that you mentioned here about the waiver?
Mr. Chairman, Representative Young, under Idaho Code right now, 2509, which under the Juvenile Corrections Act says that any juvenile who's charged with any sort of murder under any degree is an auto waiver into adult court. Right now, the way that this bill is language, it does not protect juveniles from that. Juveniles, user to user, if they get ensnared in this, are looking at an auto waiver just as and treated as an adult. So your 14-year-old who's at school is going to get ensnared in the same in this very serious problem.
Representative Gannon.
Thank you, Mr. Chairman and Ms. Fisher. So are you saying that kids are going to be subject to this maximum imprisonment of life and a $25,000 fine?
As I read, excuse me, Chairman, Representative Gannon, as I read the law presently, they would be subjected to the same penalty. Yes.
And one other question, Mr. Chairman and Ms. Fisher. So, and with the drug-induced homicide proposed statute, proposal in this bill, is there a requirement of intent in there that the juvenile would have, that the state would have to meet in order to prosecute a juvenile under this statute?
Chairman Skog, Representative Gannon, under the way that this proposal is, it's sort of a stacked. The law itself, that as I read it, does not have intent. There's certainly no criminal intent to kill. There is an intent that you have done a criminal act, which is possessing and or giving the drug to somebody else that resulted in their death. That part is the part of the intent. But there is no intent to kill. There is no intent to be a murderer in this when you're passing it off to your buddy at a party and you think you're all going to have a good time and wake up the next day and talk about it. These are not people who are intending to kill under this law.
Representative Gannon.
Thank you, Mr. Chairman. Ms. Fisher, earlier today at my request, a copy of Idaho Code Section 20-509 was distributed to our committee. Is that the law that you're referring to, that is the auto waiver for juveniles that you've referenced?
Chairman Skog, Representative Cannon, yes.
Okay. Follow, Mr. Chairman? Thank you. And so, if I understand your concern right, by statute, any juvenile that commits a homicide, which would be considered, which would be included in this drug-induced homicide if it were to become law, would automatically be treated as an adult instead of a juvenile if they were 14 years of age or older. Do I have that right?
Chairman Skog, Representative Cannon, that is how I read the law, yes.
Okay. Thank you.
I have a couple of questions.
Yes, Chairman.
Ms. Fisher, does the prosecutor still have discretion, even though that child may be charged as an adult, to bring that back down?
The prosecutor, excuse me, Chairman Scott, yes, a prosecutor will have discretion to remove the child from, could do that, yes. But on the other hand, there will be a tremendous amount of pressure, which is what this is all about, drug-induced homicide, to move forward in order to make Idaho look as serious as we are about it.
And then there's been discussion about the sentencing portion of this. There's no minimum, so a judge can also have discretion in this situation with the child, correct? As to the sentence of time. It could actually be 0 if the judge decides 0 jail time.
Chairman Scott, correct. Right now, it would be essentially an indeterminate life sentence, so it would not carry a mandatory minimum. Yes, but it is a felony, so I mean, it does require, some amount of probation. It's not going to just be you have a felony and there's nothing to your sentence.
All right, that's my 2 questions.
Yeah.
Representative Ehart.
Thank you, Mr. Chairman. Ms. Fisher, this question was probably better suited for you anyway, and given the fact that you had vast experience as a prosecuting attorney, and it is my understanding that Section 3 absolutely applies to kids, and we were told a couple days ago that it did. So this is a sincere question. I'm curious how it would go. So I'll repeat the scenario. You have a group of high school kids, and, they're not consistent drug users, but they're going to have a party. And so, they're asking, friend A, hey, do you still have the connections? And maybe it's a group of them. And he says, I think I do, but I don't have any money. No worries. Everybody, give $20, $30. They all pool the money together and they send someone off, could be any of them, to go get some drugs for a party. And they bring the drugs back, someone dies. Who's culpable?
Chairman Skog, Representative Earhart, that is a very good question. And causation in this case, under this law, it would be nearly impossible to prove. I think that it's causation in general under this law, drug-induced homicide, is very difficult to prove because you're also going to have a medical examiner who is going to be able to say with certainty that whatever the drug was that was passed, and maybe it was the last drug, you don't know what else was on board, is the one that caused the death. Remember, most people come into this with polysubstance issues and addictions. Very rarely is it just going to be one drug on board. It could be, but causation is going to be a very difficult thing to prove. And under your scenario, that is even more difficult.
Follow-up?
One follow-up.
One follow-up, Mr. Chairman. Ms. Fisher, these are some of the things that have been swirling in my mind for a while. Is the scenario, it wouldn't necessarily have to be exact, but is the scenario which I presented, given the increased and incredible amount of fentanyl in the area, am I that far off with a scenario such as that occurring based on your past prosecuting experience?
Chairman Skog, Representative Earhart, It's my belief that your scenario is not at all far off, especially as it relates to juveniles and those that are in our high schools. The other issue, quite frankly, that is a huge concern is that there is absolutely no mercy in the drug-induced homicide. There is no good Samaritan effort in this. Somebody knows what's happened and maybe they were involved in it. The way that this law reads, it is so restrictive and so punitive that there'd be little inclination to want to help. There's no mercy.
Representative Young.
Thank you, Mr. Chairman, and ma'am, thank you for being here. I found the section here, 184006, where we have manslaughter defined, involuntary and vehicular, which both in my mind have some level of parity with what we're talking about. Would you mind reminding me and the committee of the parameters for sentencing around those two crimes?
Chairman Skog, Representative Young, I had not brought up the vehicular manslaughter just because it didn't seem to really apply necessarily to what we have here involving alcohol or substance impairment. However, it certainly could. That voluntary manslaughter, vehicular manslaughter, I believe, off the top of my head, is 15 years. Voluntary manslaughter, which again is the what we think about as rage and passion. You have an intentional act, but you didn't necessarily intend the killing. It's done in rage and that sort of thing. That's 15 years with no mandatory minimum. And then involuntary manslaughter is you're committing a criminal act, but you don't intend to kill, and it results in killing. Think of road rage incident, where it gets out of hand and somebody does a criminal act by striking somebody or doing something that results in somebody's death. That wasn't your intention. That's what happened. That carries 10 years with no mandatory minimum.
Before your follow-up, I've had a request specifically from my mic and that of Representative Cannon that we speak closer to the mic. People online aren't hearing us, so. Representative Young, one follow-up.
Thank you. Mr. Chairman, if I may, I'd like to just clarify something, and then I have one other follow-up.
Go ahead.
Okay. Thank you, Mr. Chairman and ma'am. So when you say 15 years or 10 years, is that the maximum sentence or is that the floor? What is that?
Chairman Skog, Representative Young, that's the maximum sentence that someone could face for voluntary manslaughter is 15 years. For involuntary manslaughter, the maximum they could face is 10 years. There is an associated fine with each one of those, although rarely do judges impose that fine, but that is the maximum amount of time that they can face is up to 10 years on involuntary manslaughter.
Thank you, Mr. Chairman. And then just one final question. You've talked about the Good Samaritan law, and this is something that I asked about in the print hearing. I was hoping we would have more information about it. I've heard conflicting reports that, yes, the Good Samaritan law would cover someone in these circumstances, so we don't have to worry about it. And yet it sounds like you have a different opinion. If you could please clarify why it is that you believe that it does or does not apply, that would be appreciated.
Chairman Skog, Representative Young, I believe that you need an actual affirmative defense in this law, written as part of this law, that would provide an affirmative defense that says that if you were to administer aid, that it could be an affirmative defense to the crime that's been committed. We in Idaho have a Good Samaritan law for alcohol and for just high school students, college students primarily is where that's aimed, where if, as a result of what's happened on some of our campuses, where some of our students had, such high rates of alcohol and they passed out or wandered off, and other students, and they were under the age of 21, and other students did not provide any aid. And this law was created, I think, back in 2018 for the first time, but it only addressed alcohol because drugs are illegal. And so we didn't have a Good Samaritan law that would allow somebody to render aid for giving somebody drugs automatically because it's a criminal act. That's where that stopped. I think it was in 2018, 2017, 2018, that is where that stopped. So in this instance, right now, without there being a Good Samaritan or a good faith exception or affirmative action that's actually written in this drug-induced homicide law, from my reading of it, I mean, there's lots to litigate, I suppose, but I don't see that there's any effort for a Good Samaritan that would protect that person. If you're the one that gave the drug, saw what was happening, then tried to administer aid, why you would tell on yourself if you know that you're looking at up to life imprisonment.
Representative Allgood.
Ms. Fisher, thank you for your service. I appreciate that very much. Is it common when a prosecuting attorney gets a report from a police department, police officer, they read the case and determine that it probably does not fit the charge the officer is requesting, and they amend that charge or change that charge to a more appropriate charge?
Chairman Skog, Representative Allgood, it's always going to be the job of the prosecutor to look at the, to look at the case, look at the investigation and the police reports that have come in, and try to come up with a case that they can prove beyond a reasonable doubt. Sometimes we have law enforcement officers who bring in a case that they've investigated and believe that they have a thoroughly investigated a case for a murder, for instance, and a prosecutor may review all of that, look at the crime, look at the intent, look at all of that, and conclude that, it's not there, and they have to charge something else. They could also send it back to the investigator and say, you're missing X, Y, and Z. Go look for X, Y, and Z, and come back to me if this is what you really want. So they should be cooperating with each other as to, what the charges that they are pursuing and what the prosecutor ultimately can prove beyond a reasonable doubt.
Go ahead.
Thank you. And so this kind of cooperative effort, it's not an automatic situation. It's a cooperative effort between the law enforcement officer and the prosecutor's office to reach the appropriate charge in each case?
Chairman Scott, Representative Allgood, of course. I mean, law enforcement investigates cases and prosecutors prosecute. It's law and order. Think of that. Da-dum-bum, that law and order. There is a division.
Personal privilege. I watched the Blue Blood show all seasons, and I think of that prosecutor, investigator conflict. So, Representative Mathias.
Thank you, Madam Chair. Ms. Fisher, could you clarify something for me? What I've heard repeatedly throughout the testimony today is, on the one hand, that users, addicts, sometimes traffickers don't know what the law says, don't know what the risk calculation looks like based on statute, don't care, and therefore the deterrent effect is non-existent. We've been told they don't look at the law, they don't care, on the one hand. But you just suggested that if there's an accidental overdose and someone is inclined to help that person as a good Samaritan, that they might be reluctant to because there's no affirmative defense in the bill, which suggests they know what's in the law. So help me understand, when do people know what's in the law, and how do they take that into consideration?
Answer if you can.
Chairman Scott, Representative Mathias. It's a great question. Those are not easy questions just to answer out like off the top of in here. There are times when we have individuals who are users and addicts who know that it's against the law. I can't stand here with a straight face in front of you and think that there aren't addicts up there who know that the drugs that they're taking, the marijuana that they're smoking, the meth that they're shooting up, they know they're committing an illegal act, right? I mean, I can't say with a straight act that they don't know that. Now they share it with their buddy and their buddy takes it before they do, and maybe it is laced with fentanyl, or maybe it's not, but they don't know what else is already on board, and that person then starts to struggle and they die. The person that's there that gave it, they certainly know what they did was illegal. They know their drug use is wrong. That part, I think, is relatively clear. I don't know that anybody here with a straight face could say that people who are smoking dope and using meth and shooting up heroin don't know that what they're doing is wrong and illegal, and it needs to be done quietly and secretly to the extent that it's going to. So I'm not sure if I'm answering your question all the way because it's a complicated question. If it's just truly a good Samaritan who had nothing to do with the delivery of the drug, I'm at a party with my high school friends and everybody is there and all of a sudden somebody drops and I'm there and I didn't have anything to do with it and I go render aid. Well, I hope that for all of our children, for every citizen that we have, I didn't do anything wrong. I'm going to render aid. And I know that I would think that I would never get in trouble for that and that prosecutors and law enforcement officers would ferret that out very quickly. But if I'm the person that gave the drug, paid the $30 along with everybody else, was participating in it, I know it was illegal, you know it was illegal, and now you have an issue about who caused this drug-induced homicide. And that's where things become very difficult with causation or with rendering aid, help, and assistance. Assuming that, they're not so altered in their state that they know better and will try to help.
Representative Cannon.
Thank you, Mr. Chair. Ms. Fisher, I wanted to follow up on a question that I think Representative Allgood asked about the changing of charges. Is it also I want you to address the practice of plea bargaining and, the prevalency of taking a charge that law enforcement believes is a legitimate charge, but still reducing that charge and in order to kind of get the system moving and not having to try every case and so forth. Talk about the prevalence of that and kind of your thoughts on that practice in your years as a prosecutor.
Chairman Skog, Representative Cannon, the use of plea negotiations for prosecutors is a very valuable tool for lots and lots of reasons, partly to keep things moving along, partly because prosecutors may see that there's a flaw in something that was originally charged, but you have a lesser included that you could offer and you can move that case along quickly. I'm a firm believer that prosecutors need the ability to have plea negotiations and that they should be able to engage in that. And it's not a dirty word and it's not a dirty process within the criminal justice system. It quite frankly is needed and we need to move that along. Does it happen regularly and routinely? Of course it does. In my own practice, which was primarily as chief of special crimes, with lewd conduct and child sexual abuse and some of those sorts of cases, I had the practice of having to work with children, and there were some children that were never, ever going to be able to take the stand, ever. There just was too much going on, too much grief, too much pain, and they were not going to be able to do it. And I knew that, and I knew that I had someone who was really guilty of what happened. And so sometimes you have to take that route to get something for or nothing, and you're going to go for it, and you make plea negotiations, and you do the very best that you can on the case that is before you. And I'm a firm believer of that and spent my entire career trying to withhold the best standards possible. And I think that's what prosecutors primarily try to do.
Representative Alfieri.
Thank you, Chairman. Ms. Fisher, thank you. I wanted to ask you perhaps to clarify something, and that is with what Representative Ehart suggested. There is nothing in Section 3, correct me if I'm wrong, there is nothing in Section 3 of this bill that absolutely requires a charge of homicide in a scenario that was suggested by Representative Ehart. Is that right? The scenario being that where there's a party and someone takes a pill and dies. There's nothing that necessarily requires a charge of homicide be brought by the prosecutor.
Chairman Skog, Representative Alfieri, no, there is no requirement that a charge be brought forward under those circumstances. I think it's noteworthy, though, that if we're going to pass a law like this drug-induced homicide, that we all look at it and say, how effective is it really going to be? What is the efficiency of this law? Is it going to really work? We know that there are huge causation issues with it, and you already have other tools. You have involuntary manslaughter. It's much simpler to prove. I appreciate that the name drug-induced homicide is important for society. It's important for our community to recognize that we are doing something about this crime and it's got the name attached to it. But as far as actually proving it, it has huge proof problems. And you can prove this with involuntary manslaughter if that's really what you wanted to do because you thought that somebody had such a bad act or that they deserved it because of their history or otherwise.
Okay, let's give this testifier a break.
Thank you.
We worked hard.